Welcome to Employment Law This Week. I'm George Whipple. Our top story, a record high for Fair Labor Standards Act lawsuits in 2015. The number of federal wage and hour suits rose almost 8% this year. There are many reasons for the increase, including more worker-friendly rules and increased publicity around minimum wage and overtime issues. Some point to the difficulties of applying an outdated law to our modern-day economy. Jeff Ruzal has more.
We do need a new standard. The problem is that the FLSA, as envisioned back in 1938, was for a very static workforce, and that's just no longer the case. With the new on-demand economy, the gig economy, as many are calling it, it becomes increasingly more difficult for employers to comply with the very stringent wage and hour laws that we have, in part because of a transient workforce and the fact that a lot of employees do telecommute these days, and it becomes difficult for employers to maintain proper records of the time worked by employees and for employees to account for all of their time. The FLSA has to be an evolving law, and it has to be interpreted the correct way so that employers who are well-meaning and intend to pay their employees correctly cannot violate the law by what would amount to a technical violation.
Bad lever pays a hefty price. A former VP of Fortinet Inc. must pay nearly $1.7 million to the company after poaching 3 of his subordinates when he left his job for a competitor. The former VP joked in an email that the employees he took were 3 bullets to the back of the head of his previous employer. In the arbitration, a former California state judge ruled that the employee had breached his fiduciary duty and his contractual obligations not to recruit from the company for a year after he left. Business groups asked the Ninth Circuit to reconsider their PAGA waiver ruling. The Federal Appeals Court accepted 3 amicus briefs from the U.S. Chamber of Commerce and other businesses, asking the court to rethink its ruling. The court's split decision in September found that class action waivers for California employees are unenforceable under the Private Attorney General Act. This ruling reaffirms the California Supreme Court's 2014 Iskanian ruling. Temp workers are considered employees in a race bias suit. The Third Circuit recently ruled that a temporary worker assigned to a retail store can be considered an employee of that retailer. The plaintiff is alleging that management at Tuesday Morning retail stores discriminated against him and his fellow African American employees, resulting in their termination. The court found that there is a common law employment relationship between the temp workers and the retailer that satisfies the requirements for Title VII claims. This decision supports a growing consensus in the courts and from regulators that a company will likely be considered a joint employer if they control the day-to-day activities of a temporary worker. It's the holiday season, a great time to have some fun with your colleagues and celebrate the great work you've done this year. Our tip of the week comes from Kathy Williams, who's got some excellent advice on how to keep those holiday parties free from employment issues.
Surveys show that most employers continue to serve alcohol at office parties, particularly at holiday office parties, but they're taking stricter and stricter measures to control the use of alcohol and the surroundings in which alcohol is served. The steps that are being taken by employers. First, they limit the time of the office party, perhaps moving the party to an afternoon event away from an evening event. They may control the amount of alcohol or the type of alcohol that is served. They may limit the hours that the bar is open. They want to make sure that there is abundant food and non-alcoholic beverages provided to employees. Some employers are moving to cash bars and donating the proceeds to charities so that that will minimize the amount of alcohol that is consumed by employees. Many employers are assigning monitors to employees to nip inappropriate behavior in the bud and to perhaps dissuade employees from continuing to drink if alcohol seems to be the problem.
Thanks, Kathy. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.